Contract law. Consideration. In contract law, consideration is concerned with the bargain of the contract. A bilateral contract is based on an exchange of promises. Each party to a contract must be both a promisor and a promisee. They must each receive a benefit and each suffer a detriment. This benefit or detriment is referred to as consideration. According to Thomas versus Thomas, consideration must be something of value in the eyes of the law. This excludes promises of love and affection and gaming and betting contracts. A one-sided promise which is not supported by consideration is a gift. Contract law does not enforce gifts unless they are made by deed. Consideration may be executed, meaning it has been performed, or executory, which is a promise to perform in the future. There are various rules governing the law of consideration. 1. The consideration must not be passed. 2. The consideration must be sufficient, but need not be adequate. 3. The consideration must move from the promisee. 4. An existing public or contractual duty will not amount to valid consideration. 5. Part payment of a debt is not valid consideration for a promise to forego the balance. 1. Consideration must not be passed. This means if one party to the contract has already performed their side of the contract before the other makes a promise, there is no valid contract. In re McArdle, it was held that the wife could not recover for the money and time she had spent on redecorating the father-in-law's property. The promise to make payment to her came after she had performed. Her consideration was passed. Past consideration may be valid where it was preceded by a request. In Lampley v. Braithwaite, 1615, the defendant asked the claimant to do everything in his power to get a pardon from the king. After the claimant had done so, he promised to pay him £100. This promise was binding as it was performed at his request. 2. Consideration must be sufficient but need not be adequate. There is no requirement that the consideration must be market value, provided something of value is given. For example, £1 given in exchange for a house would be valid. The courts are not concerned with whether the parties have made a good or bad bargain. This was established in Chappell v. Nestle, where chocolate bar wrappers were sufficient consideration even though they would be thrown away. 3. Consideration must move from the promisee. If a person other than the promisee is to provide the consideration, the promisee cannot enforce the agreement. In Tweddle v. Atkinson, a couple were getting married. There was an agreement between the bride's parents and the groom's parents. They would each pay the happy couple £200. The couple were unable to enforce the payment as they did not provide any consideration. 4. An existing public duty will not amount to valid consideration. Where a party has a public duty to act, this cannot be used as consideration for a new promise. This was seen in Collins v. Godfrey, where the claimant was subpoenaed to attend court so could not use his appearance as consideration for a promise of payment. Where the promisor goes beyond the duty, this may be valid consideration. In Glassbrick v. Glamorgan County Council, it was held that by providing extra police officers at the strike, they had gone beyond their public duty to keep the peace. In Ward v. Byam, it was held that the mother had gone beyond her duty towards her child by ensuring it was happy. This principle also applies to an existing contractual duty. If a party has an existing contractual duty to do an act, this act cannot be used as consideration for a new promise. In Stilk v. Myrick, the claimant was a seaman on a voyage from London to the Baltic and back. He was to be paid £5 per month. During the voyage, 2 of the 12 crew deserted. The captain promised the remaining crew members that if they worked the ship back to London, he would divide the wages of the deserters between them. The captain never made the extra payment promised. The court held that the claimant was under an existing duty to work the ship back to London and undertook to submit to all the emergencies that entailed. Therefore, he had not provided any consideration for the promise for extra money. Consequently, he was entitled to nothing. In Hartley v. Ponsonby, there was a different outcome on similar facts, but a greater proportion of the crew deserted. There are 2 possible explanations of the difference. Either the remaining crew had gone beyond their existing duty, or the original contract became frustrated so they could negotiate a new one. A novel approach was taken in Williams v. Rothie Brothers, where it was found that conferring a practical benefit or obviating a disbenefit, by avoiding a penalty clause, could amount to valid consideration, even though they did no more than was stated in their original contractual agreement. If the existing contractual duty is owed to a third party, this may be used as valid consideration for a new promise. In Scottson v. Pegg, the claimant was paid twice for unloading coal. Once by the supplier of the coal and once by the customer. This was valid consideration despite the fact he was already being paid to do the same thing. 5. Part payment of a debt. Part payment of a debt is not valid consideration for a promise to release the debt in full. This principle dates back to Pinnell's case in 1602. This provides part payment of a debt is not valid consideration for a promise to forbear the balance unless at the promiser's request part payment is made, a. before the due date, b. with a chattel, or c. to a different destination. This rule from Pinnell's case was affirmed by the House of Lords in Folkes v. Beer, where Mrs. Beer obtained a judgment against Dr. Folkes. He paid the judgment but did not pay the interest. She was entitled to claim the interest as he had only partially paid the debt. There are some further exceptions to the rule in Pinnell's case. Firstly, where part payment is made by a third party. This was seen in Hirachand Punam Chand v. Temple, in which a father partially paid a debt for his son in return for a promise to release the debt in full. Secondly, promissory estoppel, the equitable doctrine established by Lord Denning in High Trees. In summary, consideration is something of value in the eyes of the law. Past consideration is not valid unless done at the promiser's request. Consideration must move from the promisee. It must be sufficient but need not be adequate. An existing duty is not valid consideration. Part payment of a debt is generally not valid consideration for a promise to release the debt in full, but there are numerous exceptions to this. This video is part of a series of videos on contract law from www.e-lawresources.co.uk. Please subscribe to our YouTube channel www.youtube.com/@e-lawresources. It's free to do so and will help us to keep providing these videos. Check out our website, which provides lecture outlines and case summaries. See also www.e-lawrevision.org.uk for revision games and quizzes. Thanks for watching.